Hello, everybody. Good morning, good afternoon, wherever you are. My name is Josh McCullough. Thank you for joining us for today's webinar, Compliance Matters, Layoffs, Furloughs, and Recalls. We have a packed hour. We are at the top of the hour, so we're going to go ahead and dive into the housekeeping items before we introduce our presenter. A couple basic Webinar 101 housekeeping items. We will be delivering a copy of these slides and a recorded version, a link to view the recording. Give us about 24 hours on that and keep an eye in your inbox. We are going to do a couple of polls. We'll kind of take a break and give our presenter a chance to rest her voice, and we'll do a couple of polls. We've designed those so that hopefully we can share the results there, and it's something that's insightful, and so we would love your participation in those polls. With that, let's move right into today's content. Today we have Kara Govro with us to cover the topic. Kara is a labor employment attorney and a compliance expert and has been diving into all things COVID-19 related, and we have a packed hour of content from Kara. So with that, Kara, take it away.
All right, thank you. Hey, everybody. It is good to be with you today, this morning for me, on my second cup of coffee now. Hopefully you've got your beverage of choice ready to go for this. We're going to talk about layoffs, furloughs, recalls, and then avoiding lawsuits, and how selection criteria are going to be key to all three of these things when it comes to keeping yourself out of trouble. So, let's get started. Let's talk layoffs first. What employers need to understand about layoffs is that they're really just terminations. We call them something different so there aren't as many hurt feelings. We're letting you go because we don't have anything for you to do, as opposed to we're letting you go because we don't like you or you're a poor performer. But functionally, they are the same. They do generally make getting unemployment insurance easier for the person who's been laid off because they can check the box layoff. But what a lot of employers don't realize is that when you terminate someone, even for cause, they're usually going to get unemployment insurance. They're only denied UI, even in a regular universe without COVID-19, if they've generally committed something that's considered gross misconduct. So if you fire somebody for being a poor performer, they're probably going to get UI. If you fire someone for being late a few times and it's, because their bus is always running late, they're probably going to get UI. So really not that different than a termination. It's more about sparing feelings, which is perfectly fine. But to that end, you need to be thinking about pretty much all the same stuff as if it were just a regular for-cause termination. So one of those items is a final paycheck. Once you decide to terminate someone via layoff, we need to figure out what our state's final paycheck law is and conform with it. So some states require that you be super fast with that final check. So California, for instance, you have to give them the check on their way out the door, so their final day of work. So you'd want to have that ready when you execute the layoff. Other states have, like 72-hour requirements. I think that's the law in several states. So you'd need to get it to them within a few days of termination. Other states that don't have a law at all specific to final paychecks, you want to make sure that they get paid by at least their next regular payday. There are a few states that require that PTO be paid out. If you're in one of those states, make sure you do that. You also want to make sure you're not taking deductions that you shouldn't be taking. So a lot of employers are under the impression that they can just take a deduction for something an employee doesn't return, like a laptop or a uniform. That's generally not the case. Generally, you need to at least get their signature saying that they're okay with that kind of deduction ahead of time. Sometimes you can't take the deduction at all, depending on what state you're in. Also, even if your state does allow for some deductions and you take one legally with all the right paperwork, if it takes their final pay below minimum wage for that pay period, or cuts into their overtime for that pay period, that's going to be a wage violation under the Fair Labor Standards Act. So even if you are allowed to take a deduction, make sure you do the math before you actually issue that final paycheck, or you could be getting yourself in trouble. We also should let employees know about their right to file for unemployment insurance. So some states require this anyway. California, for instance, even when you terminate someone for cause, you're supposed to give them a notice, and this is pre-COVID. You're supposed to give them a notice telling them that they could apply for unemployment insurance. Now, the CARES Act, which was passed, like 6 weeks ago by the federal government, requires that states tell employees that they can file for UI. And then some states are passing that obligation on to employers, which does make sense. Not all states have done that yet, but the advice I'm giving is, instead of trying to figure out whether your state is one of those states, just let them know. So you should spend some time on your state's unemployment insurance website, right? If you haven't done that yet, go there or plan to commit an hour to browsing around, reading all the guides, all the FAQs, learning what work share means and what partial unemployment is. Learn about these things so you can answer questions for your employees, because they will have questions. If you spend some time there, you will also run into any notices that you need to provide. So it's very possible that your state will have a notice that you can just download and hand out. If your state doesn't have one of those, I would encourage you to just find a way to let employees know anyhow. So you could write that into their termination layoff letter. You can send it as an email, whatever. Just make sure they're aware of it. My gold star here, meaning this isn't really compliance, it's just something that I think is a best practice and would make you a nice employer that they'd want to say good things about on the internet, would be to provide additional information like FAQs and guides and whatever you find on the state unemployment insurance website. Make this experience a little bit less stressful for those people if you can. Someone asked about laying off remote employees. The question was specific to California, but basically if you lay somebody off remotely, you need to do whatever you can do to meet the requirements as best you can. So if you're laying somebody off in California remotely, I would send them a check via overnight mail. That's really the best you can do. I wouldn't send it first class mail. I would send it, FedEx overnight, UPS, whatever. It's possible the first class mail would actually be compliant, but I don't have the regs in front of me. With any of the things we're talking about today, if you're not sure that you can comply perfectly, you should always do your best, right? Good faith won't be a defense to wage and hour claims, but some of the things we're talking about today, they don't have penalties written into law. They're based on new laws or changing laws or regulations. So if you run into something where you're like, oh, shoot, I didn't do that perfectly, or I don't know that I can do it perfectly, do your best. Get the closest approximation to the law and, and call it good. If you absolutely can't comply, then just do your best. Laid off employees also need to be given notice of their right to continue benefits. So if they have health insurance through you, they will be losing it. And that means they'll be entitled to COBRA if you have 20 or more employees. That's at the federal level, or probably mini COBRA at the state level. So almost every single state has a mini COBRA law, which applies to employers with 2 to 20 employees, or 1 to 20, or 1 to 19, I should say. So chances are one of the two COBRAs applies to your employees, and that gives them the ability to stay on their group health insurance, but pay the entire premium themselves. So it can be very expensive. Not everybody is going to choose that, but it is something they do need to be offered. So your obligation is actually to notify the administrator within 30 days. They then have 14 days to send the notice, or if you're self-administering, you actually get all 44 days to do that. Gold star, though, provide the election notice at layoff if you can, or tell your administrator as soon as possible once this person has been laid off. If you wait the full 30 days and they wait the full 14 days, that person will probably lose coverage in the meantime. And even though COBRA will be retroactive, it's a real pain for an employee to have that uncovered period of time. Bad things happen, they may have to pay out of pocket, or, the bill's going to come, it's going to be larger, and then they're going to have to retroactively get insurance to cover it. It's a mess. I've had friends go through it. So please notify the administrator as soon as possible and get that ball rolling so they can hopefully not lose coverage at all. I also think it's a really good idea to let employees know about other health insurance marketplace options. So about a dozen states and DC run their own marketplace. So you'd want to go find the state link. If you're not in one of those states, and you can find this really easily by just searching health insurance marketplace option, your state name, this will come up for you. If you're not in one of those states that has a state marketplace, you'll just, give them a link to the federal marketplace. So the point of this is, like I just said, COBRA is very expensive or can be very expensive. These marketplace options may be less expensive. You are not obligated to tell an employee about this. This is not required by law. I just think it's the right, nice thing to do. For even more gold stars, I would provide some additional resources as well, along with their sort of layoff package, whatever that may be, final paycheck, COBRA notice, and then this stuff. So state unemployment insurance department links, if you found anything that was good or useful there, like FAQs or guides I mentioned before, link them to that. Governor's website may have good updates on, executive orders, general safety information. You could also link them to the state health department or the CDC, just so they can sort of keep up with all that stuff on their own. Again, don't have to do this. This is just to be nice, just to be helpful. Depending on the demographic of your employees, it might be helpful to link them to local food banks or other charities that are helping people out right now, as well as renters resources. So a lot of states or cities are suspending evictions right now, and if you can locate the page, the government website page that explains that, it would be really great to direct your employees to. And then information about marketplace insurance options, like I mentioned before, could be a good addition to the sort of like care package email, so you can save them a little bit of time. You'll also want to make sure that you're complying with WARN. If you have 100 or more full-time equivalent employees and you're laying off 50 or more of them. So if that sounds like you, I would encourage you to Google WARN or go look at the laws page in the HR Support Center about WARN that gives a little more detail, but this slide covers most of it, to be honest. WARN is the Worker Adjustment and Retraining Notification Act. It's a federal law that basically says you need to give 60 days advance notice if you're going to lay off a ton of people, like a good portion of your workforce. There is an exception for unforeseen business circumstances. So, if COVID-19 hit, your state shut down your business because it was non-essential and you laid everybody off, that would definitely be an unforeseen business circumstance. At this point right now, though, if you're just anticipating a lot of layoffs because you think business is going to be slow in the future and you sort of see the writing on the wall, I don't know that it's really an unforeseen business circumstance. Even if you do use the exception, though, you want to provide as much notice as possible. So maybe you do see the writing on the wall, but you think you need to do these layoffs, 30 days from now. You can't wait 60. You won't have the money to wait 60. So give 30 days notice. You're not going to have to write a letter to the DOL saying you complied with WARN, but you could be liable for not complying later. So do your best on this one. This is another one where if you can't be perfectly compliant, do your best. A few of you have chatted in asking if you're going to get a copy of the slide presentation, and you will. You'll get a copy of the entire slide presentation as well as the full recording with audio. So you will get that in the future, within 24 hours, in fact, or around about 24 hours. All right, let's talk about furloughs now. So they're a lot like terminations, but also not like terminations. Some of the most important things that happen in a termination will take place, others won't. So let's talk about the differences first. During a furlough, that employee is still on the books, right? We have not officially ended the employment relationship. PTO payout won't be necessary if you're in one of those states that requires that, because we're not giving a final paycheck, right? However, if, for instance, in California, you furlough someone indefinitely, that will trigger PTO payout. You'd want to put a recall date in the letter or a recall condition, such as soon as our business is allowed to reopen under the phased reopening program that the government has laid out or the governor has laid out, you will be recalled. So it may not be an exact date, but it might be a condition. We're off this topic now, but somebody chatted in a good question. They said, I thought WARN was for 50 plus employees. So like mini COBRA for states, there's also mini WARN. So that's a great call out. I'll actually put that on the slide before we send the deck to you. Thank you for that. So some states have their own WARN programs that apply just like mini COBRA at a lower employee threshold. So what I was showing you was the federal WARN Act. There may also be a state WARN at play. So you'd want to check that out. Good call. All right, coming back here to furloughs and layoffs though. Like I said, that last paycheck isn't a final paycheck. It's just their last paycheck for a little while. So we don't need to do the final paycheck dance in terms of whether it's now or 72 hours from now. You can just give them their final paycheck on the next regularly scheduled payday. Most of your employees probably have direct deposit, in which case, just let it do its regular direct deposit thing. So I mentioned that some of the big things that happen for a termination will also happen for a furlough. First up, employees will be eligible to apply for unemployment insurance. I feel like a lot of employers didn't know much about UI a couple months ago, and we're all learning a lot now. We're going to be good at this UI thing a year from now. So yes, your employees can get unemployment insurance even if they're still on the books. They can probably get unemployment insurance even if you've just reduced to their hours. So give them information about that. They will also probably lose their health insurance coverage unless the furlough is, really just a slight reduction in hours or, 1 day off a week, which there's no sort of legal definition of furlough. It could be just a reduction in hours, or it could be entire weeks taken off. For the most part, I'm talking about entire weeks taken off right now because that's what most employers are doing. But technically, a furlough could just be a reduction in hours. So will furloughed employees be eligible for health insurance? I said they'll probably lose it or they might lose it. You're going to need to look at your plan documents. So most plans will say that employees are only eligible if they're regularly scheduled to work 30 hours or more per week. Not every plan says that, but that's pretty standard. So if you, put them off work for the next 3 weeks or 6 weeks, they are not regularly scheduled. So technically under, that plan provision, they would lose coverage. And of course, we need to not be committing insurance fraud. So we need to, report accurately whether an employee is regularly scheduled or not. That said, even if your plan document seems to make it clear that an employee would lose coverage, there might be some new flexibility provided either by the carrier or by the state forcing the carrier to provide flexibility. So a lot of carriers right now are agreeing to changes, and a number of states are requiring that carriers give employers the option of maintaining coverage for employees who are furloughed or have had their hours reduced. There's one other way that you might have furloughed people maintain health coverage, and that's if you're an applicable large employer, meaning you have to offer health insurance because of the ACA, and you use something called a look-back measurement method to determine eligibility for group medical coverage. So if you are using that method, then employees who are deemed full-time for a stability period, that's a term of art, it's a defined term, won't lose eligibility during that stability period, even if they're furloughed. So if these words sound familiar to you, that's something to look into. It's possible that your people won't lose coverage if you're using the look-back method. If none of that sounds familiar to you, then just, sort of follow along with those first couple slides. If none of those potential continuation scenarios apply, where, your carrier is being flexible, or maybe you're using that look-back method, then we're back where we were with the layoff. So we need to provide COBRA notice or mini COBRA notice, tell our carrier as soon as we can so they can get the ball rolling. And once again, I'd recommend pointing employees toward the state or the federal insurance marketplace, where they can, hopefully check out potentially less expensive coverage. We'll also want to, once again, notify employees of their right to file for unemployment insurance, because they can. You'll also want to determine if you have any unemployment insurance obligations. So in Georgia, you actually have to file on a furloughed employee's behalf, which is crazy. That totally sounds like a California law or a New York law, but it's actually a Georgia law. So if you're in Georgia, you need to file on behalf of that employee. You also might get a letter from the state that says, okay, we acknowledge that these people have been furloughed. Please tell us when they come back, so we can adjust accordingly. So pay attention to any correspondence you're getting from the UI department. And I mentioned this before, but I think now is the time to go learn about partial unemployment, eligibility, and work share programs that are available in your state. Most states had partial unemployment before. About half the states had work share programs, but because of the CARES Act and the new pandemic unemployment compensation thing, states are being encouraged to implement work share. So things are changing super rapidly at the state level, and that's just really something each employer needs to keep an eye on, and each individual who is trying to apply. Unfortunately, that's not something where there's going to be a big, broad federal edict that makes this easier. We will each have to battle our own state's unemployment system, and I don't really mean battle like fight with them, but so much as keep calling and keep trying to get in through the website, whatever the system may be. I know a lot of state UI systems have had to be recoded, and the code is like 40 years old. It's some coding language that nobody knows how to speak anymore. It's dead language like Latin. So they're struggling to get things up and running. I know where I live in Oregon, that's still the case. So keep trying. And this is one of the reasons I think it's helpful to give employees as much information as you can find for them ahead of time, because it's a real struggle, at least in some states. And the more you can sort of help them out during this stressful time, the better. They're the ones that are out of a job right now, and at least for a few weeks, probably out of money. So do what you can to help them out. This slide probably looks familiar. I brought it up for layoffs. I'm bringing it up again for furloughs. I've added a couple bullets at the bottom, though. So one is for your employee assistance program. You may or may not have this. These are usually called just EAPs for short, and they're programs that cost very little to the employer, usually between 75 cents and $2 for each employee per month. And what it offers them is resources for tough things that happen in life. Like if they need, some financial counseling, or they're going through a divorce and it's hard, they need a little bit of therapy. This is a program that they can use and sort of get connected with people who are sort of like life coaches, if you will. And if you've got an EAP right now, it's possible that your furloughed employee will still be eligible to use it. Sometimes they're bundled with health insurance, sometimes they're not. So if you've got one of those, feel free to, or I would encourage you to give them the phone number or the website or the link or whatever so they can access your EAP if you've got one. Also give them contact information for payroll and HR people who can answer additional questions. And you might be saying, oh, well, they can look that up if they need it. It's hard to look things up at times, particularly if your access has been limited to company stuff or company websites. So even if that's something you think is readily available, I would encourage you to just, make it easy for them to find anyway. Final thought here is that keeping in touch with your furloughed employees will be sort of essential for their mental health. When you've got an employee who goes out on ADA leave, let's say, and you don't know when it's going to end, you don't know how long they'll need, and you ask them to keep in touch and you don't hear anything for weeks, and then a month, and then 2 months, you wonder if you still have an employee, right? Well, employees who've been furloughed are wondering if they still have an employer. So I would strongly encourage you to keep in touch. I recommend weekly. One of my colleagues was like, whoa, that's way too frequent. I don't want to have to try to talk to people weekly. But I would go ahead and do it anyway. That's just my advice. Take it or leave it. But you're only going to share what you know, even if it's not very much. Just telling employees, hey, we've got no updates, but don't worry, we haven't forgotten that you're out there, can be helpful. Okay. I'm going to pause for a moment here and have Josh run a couple of polls. We'd love your feedback on these.
Cool. Thank you, Kara. We're going to do a couple polls. Like Kara said, let me launch this first one. The question is, which best reflects your outlook for your business over the next 3 months? So completely anonymous. We'll share the feedback. We'll get a sense of how your peers are feeling here. So we are off and running, 25%. We'll give this just a second. I'll take this opportunity to just remind you, we will be providing the slides and the recording. Give us about 24 hours and keep an eye out on your inbox for those. We're at 60%. I'll give this 3 more seconds. 3, 2, 1. Okay, let's end this poll and I'll share these results. So looks like somewhat optimistic, followed by very optimistic. So that is, I guess, optimistic in and of itself with those answers. Hopefully this type of webinar can relieve any of the pessimistic feelings or some of them, or make them easier to deal with. We know some of these challenges and struggles from a compliance standpoint can add to that pessimism. So hopefully you're in the right place to get some value from today's topic. So let's close this out and we'll do one more poll and then I'll kick it back to Kara. Poll question number 2. Launching now. This one is multi-select, so you can choose more than one here. What topics would you most like to learn more about in future webinars? So considering current events, considering your current challenges, which of these topics would be most beneficial to get a full hour deep dive on to learn more about? Handling COVID layoffs and furloughs, recalling employees and determining who to recall, legislative guidance, creating safe workplaces post-COVID-19, re-engaging your workforce through training. This is kind of a unique one there. And then OSHA guidance, OSHA and COVID-19. What do those considerations look like? So again, we're at 60%. Thank you so much. This is great participation. We appreciate that. I'll give this 5 more seconds and then we'll close it out and share the results. So 3, 2, 1, great, 70%. Let me share it. Looks like number 1 is creating safe workplaces post-COVID-19. So keep an eye out for future events on that. It's something that's already in the making, followed by legislative guidance. We will be looking at future events that deep dive on the FFCRA and things of that nature. So yeah, great feedback there. Thank you so much for your participation. And with that, let me pull these polls down and we'll kick it back to Kara for the next segment of content here. Kara?
All right, thank you. Okay, let's talk about recalling employees, getting them back. This part's a little bit less depressing. First, we'll talk about paperwork. Mostly there's paperwork for rehires after a layoff. A lot less we need to do for furloughed employees. In fact, like probably almost none. So if we've fully laid someone off, So we officially ended the employment relationship. They were gone, but we might have said, hey, we hope to bring you back someday. Then we're pretty much going to treat them like a brand new employee with respect to giving them an offer letter, getting them enrolled in benefits like we would usually enroll someone in benefits, reporting to the state that we've got, a new employee. That's the thing you probably usually need to do. And, pretty much all the new hire information will apply to someone who has been rehired rather than just called back from a furlough. They should fill out the new W-4. So there's a new W-4 this year, and my feeling is that nobody likes it because it's a lot more complicated than the old W-4, but you need them to fill a new one out. If they don't fill a new one out, you're supposed to list them as like a single filer with like one exemption. I don't want to get into the details on that, but basically have them fill out a new W-4 even if they don't want to. And that would be the new version of the W-4. You don't need to have them fill out a new I-9 if you're rehiring them within 3 years of completing their original. But you should fill out section 3 about rehiring. You're basically going to put a date in there. So just follow the instructions on the form for the I-9. If they'd worked for you for 5 years and you're now bringing them back, then you do need to get a brand new I-9. So basically an I-9 is good for up to 3 years. Even if you bring them back during that time, after 3 years, it's stale, you got to get a new one. People who were furloughed don't need to fill any of this stuff out because you never fired them, right? They were never terminated. You never ended the employment relationship. You just sent them home for a couple of weeks. So you don't need a new I-9. You don't need a new W-4. You don't need new reporting to the state because they were never severed as an employee. They were never released out into the wild. They've always been yours. They never left payroll, so you don't need to do all the new paperwork. When you're recalling from a furlough, though, I do think you should have a new offer letter, unless absolutely nothing has changed and the furlough was very short. If it was a longer furlough, if you were sort of rejiggering the company, which I think a lot of organizations are, if you are, deciding to lay off some people who were furloughed, and so the people who are coming back are going to have slightly different jobs, then I think the offer letter is really essential. So you want to cover any changes to their position, their pay, their reporting structure, or their responsibilities. So if this has changed dramatically, you'd probably want to just attach a whole new job description. If it's only changed a little bit, you can, cover that really easily. We have created a form, I think it's called Recall from Furlough for COVID-19, something to that effect. It's available on the HR Support Center. So we've done the heavy lifting on this one. You don't need to think this all up yourself. We've got a form available for you. You just need to fill in some blanks. Listing the steps you're taking and the policies you're implementing to keep the workplace safe is just a way to sort of smooth things over. A lot of people are concerned about coming back to the workplace and whether their employer is going to sort of do the right thing, make it safe, enforce social distancing, all the rest. So giving them that information ahead of time may alleviate some fears and might save you some time. Somebody asked, is 6 weeks on a furlough short enough for no letter? It's more about job responsibilities when it comes to whether the offer letter is important in terms of creating sort of a new contract. If the job is identical, then no, I suppose you really don't need a new offer letter. But I do think you should communicate the things in bullets number 2 and 3. So even though it's not technically an offer letter, it's still a recall letter because we want to tell them if there are new policies they need to follow. And bullet number 3 in particular, we want them to indicate whether they're coming back or not. For our records, for unemployment insurance records, if we get sued in the future about who let who go or who didn't respond to whom, we want a part of that letter to say, you were invited to come back, please check the box. Yes, I'm coming back. Yay. Other box. No, I'm not coming back. I would like to resign. And then on top of those two boxes, we're going to tell them, hey, if we don't hear from you within 3 days or 7 days or 10 days, we are going to assume that you are resigning from your position, and we're going to go through the process of officially terminating you. So not only do we ask for them to respond directly, but we warn them that if they don't respond directly within a certain period of time, we are going to assume that that's a resignation. When you bring somebody back from furlough, if they lost their health benefits, you should be able to restore them on the first of the next month. So most of you are maybe familiar with the fact that you can't really enroll people mid-month like ever. It's just not a thing that carriers allow. But you shouldn't have to wait the full first of the month after 60 days or 90 days of employment or whatever, like you would with a new hire, because they're not a new hire, right? They were just furloughed. They were temporarily not scheduled enough hours to have benefits, but now that they're back, you should be able to get them on the plan again at the first of the next month. You can check with your carrier if you want, but from what I've heard, carriers usually answer back, hey, just make a policy and follow it. We're good with that. Somebody asked what's a reasonable time frame to give people to respond to your furlough letter. That's really going to be up to you. How fast do you need them back? And how sure are you that the way you communicate with them is going to get through to them? So this is something I actually spent a lot of time on in I think on another slide that's coming up, but but I'll talk about it now anyway. You want to make sure that you're communicating with employees in a way that will be effective, right? So first of all, when you let them go out on furlough, make sure you have good contact information. If they've worked from you for a couple of years, it's possible that you don't even have their current phone number or their home address. It's possible that when they started working for you, they filled out, the application with a burner email address or a fake email address. Who even knows? So when you send somebody off to furlough, make sure you have good contact information and that you tell them to actually check that account or that phone number or whatever it may be. So if you feel pretty confident and you've done your best to tell them to check those accounts or look in the right places, then I think you can allow less time, maybe 3 days, 4 days. Again, it really depends on how fast you need them back. I think a week is probably more reasonable, but really your call. That's going to be a business decision. Perhaps the most common question we're getting right now, and I mean, we're getting this question a lot, is what do we do about employees who don't want to come back, who are perhaps making more money on unemployment insurance than they were working for us, or, they're saying, oh, I can't come back because I'm afraid, or I can't come back because I've got a sick relative. The answer is that it really depends on their reasoning. And I suppose the question is, for employees who don't want to come back, will they get unemployment insurance? This seems to be the question that employers really want answered. Are they still going to get money, or will they be, punished for not coming back to work by not getting unemployment insurance? Is that any leverage for us? And like I said, the answer is it depends. So they probably will keep getting unemployment insurance benefits if the following is true. If they are high risk and you can't accommodate them sufficiently, like by letting them work from home, they'll probably get UI. That is a specific expansion of unemployment insurance right now. They're out of work through no fault of their own because it's too risky for them to go into the workplace. We do not require people to sacrifice their lives to go to work. They can find something else. It's not their fault that they can't go to work. They've got a high-risk condition. So if they are high risk and you can't accommodate them, then they'll probably get UI. If they have children to care for whose schools are closed because of COVID, they will get UI. If they're caring for people who are sick or quarantined because of COVID, they'll probably get UI. And if you're not offering a workspace that meets safety guidelines, they will almost certainly continue to get unemployment insurance. If it's not one of those reasons, they probably won't. So generalized fear of going out into the world, no, they're not going to keep getting UI. You know, if they've got a relative who is high risk, they probably won't get UI. In that case, I would encourage you very strongly to sort of negotiate with them and come up with a reasonable accommodation so that they don't end up killing their family member because they've come to work in a high traffic area and then taken COVID home with them. We'll talk more about that a few slides down the road. So what can you do if you think they're planning to commit unemployment insurance fraud by declining an offer of employment when they don't have a good reason to do that? Well, you can report them. And states are making this easier. So they're creating reporting systems, either phone numbers or online systems, where you can go and say, hey, I offered this person work and they declined it. All right, and then we let the state deal with it. If the employee commits fraud, that's not on you. Don't stay up at night worrying about, you know, the fact that they're going to get free money. We got to move on in life. But states and of course the federal government as well, they do see that you know, the system is rife for fraud, and they're trying to do some things about it. So if you think somebody is about to commit UI fraud because they've basically told you that's what they're doing, you can probably call the state unemployment insurance department and report that. I made a little note that if they've got kids or they're caring for someone with COVID, this is a little bit complicated by FFCRA leave. If they're telling you, I literally can't come back right now at all because I have to care for a child, and you need one person to come back, it will probably make sense to leave that person furloughed and bring back a different individual who can do the same thing. However, if you only have one person who does that thing, you might want to bring that person back and then negotiate with them to sort of take FFCRA leave intermittently, perhaps. My note here is that basically this is complicated, and we haven't been told exactly how we're supposed to deal with FFCRA leaves and how they might interact with bringing people back from furloughs. So we're keeping an eye on that, and as soon as we get any info, I assure you that there will be, you know, an email blast or a big sign on the website letting people know that we know how that is supposed to work right now. If you do have HR on demand, we can sort of talk you through that problem. All right, let's spend some time now on deciding who to bring back or who to lay off or who to furlough. So you might be in a position right now where you've laid everybody off and it's time to bring some people back because we've got some reopening happening. Or perhaps you have furloughed everyone and you know who you're going to recall already based on business needs, and you need to lay some people off officially. These kind of all go hand in hand. So what's important is that we have non-discriminatory selection criteria and that we document the heck out of all of this, all right? So obviously the first thing we're going to do is consider our actual business needs. So do we need, you know, all of one department and none of another department? Do we need 50% of everybody representing every department? What you would like to avoid is calling back more people than you need and then having to furlough or lay them off again, because that will interfere with their unemployment insurance claims and cause them, you know, issues with steady income flow. You know, if you if you have to keep restarting a claim, that can be a real pain, particularly right now with the systems being the mess that they are. So start by underestimating how many people you need to bring back so you don't have to do this like furlough dance with people. They're not going to like that in the end because it's going to cost them money and heartache. If you went through 2008 to 2010 or 12, whenever it may have ended for your industry, if you experienced that economic downturn, you might have some information as to, you know, who you will need when business slows down. That's something you can think about. Once you have sort of thought through your business needs, then it's time to start looking at individual employees. So this is assuming we're not bringing back every single person or every single person in a department. This is when we're going to have to make some hard decisions, either letting them go or bringing them back. So we want to look for job-related reasons to, again, let somebody go or bring somebody back. So potential criteria might include unique or difficult to replace skill sets. So if there's somebody who you know it's a real pain to get somebody who can do that particular thing for you, you might want to bring that person back sooner than later. Because if you furlough them for a very long time, they might start looking for different work. Not everybody is going to make more on unemployment insurance than they did working. That's for sure. That may be true of most, low wage earners for sure. But, people who are making the median and better aren't necessarily making more on UI. They're probably not. So if you've got people out there on furlough who have skill sets that you really need back, you might want to consider bringing them back first. Overall performance is obviously going to be a good metric to use. Bringing back our top performers will presumably make our business run as best it can. Seniority is easy pickings, right? This is really objective. It's a low risk, but when we're trying to operate lean, seniority might not be our best option because it might not reflect those skill sets or overall performance. You also may want to consider demonstrated ability or willingness to do work outside their usual assignments. So for instance, let's say you're a small law firm, you've got, 2 attorneys, 2 paralegals, and a receptionist, and you're bringing everybody back, but the receptionist is going to need to take care of her kids part-time. So you will need, the paralegals or the attorneys to sit in at the front desk and occasionally answer the phone. Are they willing to do that? Is one of them like, no, I refuse to answer phones. That's beneath me. Well, that might be the person you call back last. I guess I said we're bringing them all back, but let's say we're bringing back 3 out of 4 of the attorneys or the paralegals. We might want to consider who is willing or unwilling to sort of sit at the front desk there and do things outside of their usual job description. And you can figure that out by, past behavior, or when you send out that offer letter, you can write in there, hey, we know we're going to have some coverage issues. We need people who are willing to, do stuff that's not in their job description. Is this you these days? Somebody asked, if we bring some people back, but on a part-time basis versus full-time, is this a good practice to use for that situation as well? Absolutely, because bringing somebody back part-time instead of full-time will be considered an adverse employment action. So, they're going to lose money on it, basically. At least, by the time the special unemployment insurance ends, it will definitely be an adverse employment action. So we want to make sure we can support it with good business reasons. Hopefully you've got documentation, for one or more of the criteria we just talked about, but if not, there are some other places you can look for it. For instance, if somebody's got a history of tardiness and you have been historically bad at writing people up for that, you may have documentation of it in your login system, or the timesheets they fill out every week may reflect that they're frequently late, even if you haven't been writing them up. If you're paying people on a per thing basis, a fee rate basis, or they're salespeople who get commissions, even if you're not noting this all in their personnel files on their pay stub, you can figure out who the top performers are. This requires a little more digging, but if you've got nothing else, you can hunt around for emails or messenger conversations that indicate that people have or have not responded to you in a timely fashion and done what you asked them to do. Somebody asked, is there liability in laying someone off and not bringing them back because of performance issues instead of making a new hire for their position. So I think the question is there any harm in calling something a layoff when it's not, when it's actually for performance issues? I would encourage you to be truthful with your language. If you actually did sort of lay everybody off, you know, early on in the COVID thing because you got closed down, then no, there's not any special risk in bringing back new people because you were legitimately out of work for them to do, and now you want to hire new, better people. But people are not required to be rehired after a layoff. If you've only furloughed them and they think they have a job, then we want to make, you know, that official so they can sort of move on to the next thing. In general, though, you don't want to call something a layoff when it's not, because that could look like fraud to the unemployment insurance department. They can see that you're trying to help somebody get UI when maybe they're not really entitled to UI. However, as I said early on, poor performers who are terminated for that reason usually do get UI. So again, don't lie. There's no use in lying about that. This gets a little complicated. I mean, it is and it's not. Really just tell the truth. And, you know, I encourage you even to tell the truth to employees. Don't tell them it's a layoff if it's not a layoff. That will just lead to more confusion and more potential for liability down the road if they decide to come back at you and you know, lied during the exit interview or in their personnel file. In a lot of cases, we're of course going to have our managers helping us figure out who to lay off or who to bring back. So we want to be checking for bad reasons and ulterior motives. I can't tell you, you know, how many times we've gotten a call about a pregnant employee who has performance issues. And we say, well, has that person's performance issues been documented? And they say no. You know, and it looks like pretext. You have no documentation that there were performance issues. She tells you she's pregnant, and all of a sudden she's a poor performer, and we want to get rid of her. Well, a jury of your peers can see through that. A judge can see through that. Attorneys can see through that. So, you know, when you're asking your managers for their recommendations, they too should have some documentation for you. And if they don't, they should create it, and you should talk through that with them. And in particular, keep your eye out for people who may be in protected classes and things seem a little fishy and you're really not sure, you know, why that person was selected. Things you don't want to consider are age, disability, use of leave or requests for reasonable accommodation, pregnancy, or any of the other protected classes, whether they're protected by federal or state law. Age is sort of a double whammy. I want to talk real quickly about disparate impact. So I know that some employers may be taking the approach of cutting the high earners right now because it's the simplest way to sort of get money back from payroll. That might in fact be one of your criteria, just out and out. It's sort of like backwards seniority, right? You're going to get rid of the people with the most seniority because they're paid the most. That might be okay and legal, but I would certainly talk to an attorney. Disparate impact is a legal claim that can be brought when you do something that looks logical, like cutting the high earners, but it has a disparate impact or a disproportionate impact on a certain protected class. And in particular, that would be age if you're cutting your high earners, because on average, our, you know, older folks are higher earners. So if that's going to be one of your criteria, that may be legal at the end of the day, but you should talk to an attorney if you're planning to do that. We don't want to do employees any unasked for favors. This is huge right now. So employers are thinking, okay, we're going to call people back from furlough, or we're going to call some people back, you know, either call them back first or decide not to call some people back at all, and we'll turn them into layoffs or terminations. And they're thinking, okay, well, we'll bring back the old people last, or the people who are high risk, we'll bring them back last. while that may ultimately be what you do, it needs to be because the person brought that up themselves. It's not your job to make health decisions for those people. So for instance, as a general rule, if you've got a pregnant employee, you should not be creating lifting restrictions for her that she didn't ask for. So the same thing applies here. If you've got, a few people who have high-risk conditions or a few people who are, over 60 and they're on furlough right now, you should not decide to bring them back last because of that. Issue your recall letter and let them decide. In the recall letter we've created, there's a sentence that says something like, please contact us if you have, any concerns about your safety or need accommodations. It says something like that. So what we're doing there is inviting a request for reasonable accommodation. That is something required by the Americans with Disabilities Act. So if you have 15 or more employees, the ADA applies to you. It's also possible that there's a state law, like Mini Cobra and Mini Warren, that applies at a lower number of employees. So you should probably just assume that you have an obligation to grant reasonable accommodations for people with disabilities or people who are basically high risk under the current circumstances. That could be recalling them last. A lot of them will probably ask you for that point blank. Just don't make assumptions about what they want. It could be an extended unpaid leave if they're unable to work from home. If they can work from home, that's going to be a really obvious reasonable accommodation for those folks. They might want to wear additional PPE. That should be allowed. They might want to take extra breaks or sit further away from their colleagues. There are all sorts of reasonable accommodations under the circumstances, and we should definitely be considering them. Finally, I want to put it out there that compassion is perfectly legal. Discrimination is only a problem if it's motivated by someone's inclusion in a protected class and it leads to an adverse employment action. So employers can get really wound up thinking that treating anybody differently ever for any reason is going to get them in trouble, and that's simply not true. If you've got someone asking to stay furloughed longer because their wife is undergoing chemotherapy and is immunocompromised, there's absolutely no discrimination in allowing that person to stay furloughed longer. It's not an adverse employment action in that case if they have asked for it, right? It's not based on their inclusion in a protected class. It's based on you being, a good employer, a compassionate individual who sees the risk there and sees the anxiety and doesn't want to be the cause of an unnecessary death. So keep in mind that you can consider things outside of protected classes. It's only protected classes, and it's only when something bad happens as a result. You can treat employees differently because they've asked you to, or because they have, another good reason. All right, one last question. Somebody says, is this webinar good for SHRM or HRCI credits? It is, but you need to self-submit. We don't have a pre-approved code for you, but this would definitely qualify as something you could get credit for. All right, with all that said, I'm going to turn it back over to Josh to wrap things up.
Great. Thank you, Kara. Appreciate that. Just want to really quick highlight a few resources that we've created to help with some of these content areas that Kara's talked about today. We do have a fresh return to work checklist that really provides a framework for employers as they start to think about or even execute the process of reopening and getting people back to work. So make sure you check that out. It's at the HR Support Center. And then another piece that's near and dear to Kara, I believe she wrote this. This is a quick guide, if we can go to the next slide, Kara, called Deciding Who to Recall from Furlough or Layoff, a detailed quick guide talking about a lot of the points that were discussed today. So to access these, go out to the HR Support Center. If you have questions on how to do that, please contact your representative at the provider that referred you to today's webinar. With that, thank you everybody for attending. We will get you the recording link and the slides here in about 24 hours. When you exit today's webinar, there's going to be a really short 30-second survey, really quick. It's anonymous. It's just, was this helpful? We'd love to get your feedback on that. So thank you for any participation in that. Thank you for stopping by today. We hope this was helpful, and keep an eye out for more webinars in the future. Thank you. We hope you have a great day.